Hello everyone, my name is Varsha Dhakar. In this video, we will talk about the appointments of director and their qualification. First of all, I will tell you what is a company. A company is an artificial person having a separate legal entity and a common seal. A company cannot perform its own function, so company needs a human agency. That is here comes the role of a director. Directors are the backbone of a company. The Companies Act 2013 under Chapter 11 consists of Section 149 to 172. It provides the appointment, qualification, and responsibility of our directors. These individuals are the driving force behind a company's operations, ensuring compliance with laws, making important decisions, and safeguarding shareholder interest. Now, we will talk about the definition of a directors and other definitions. It provides who are the directors. Definition, it is provided under Section 2, subsection 34. Directors are individuals appointed to manage and oversee the company's operations. Now, Board of Directors. It is defined under Section 2, subsection 10, defines the board or board of directors as the collectively body of directors responsible for a company's governance. Next, a board meetings. A board meetings refers to a gathering of the board of directors to discuss and make decisions regarding the company's affairs. Under Section 173, it provides that a board of directors shall conduct a meeting at least 4 times in a year. Now, we will talk about the types of directors. Here comes the 3 types of director: executive director, non-executive directors, and independent directors. Executive directors are those directors who handles the day-to-day operations of the company. On the other hand, non-executive directors are those directors who are not involved in daily operations but provide strategic guidance and outside to the company. Then independent directors. It is provided in the Section 149, subsection 6. It defines independent director as those which no significant financial ties to the company, ensuring unbiased decision making. These are the independent directors are the most important directors for the company because these are not like nominee director, alternative director, and additional directors, because that person hold a personal integrity in the company, without which important decision cannot be taken by the company. Now, we will talk about appointments of directors. Who can appoint directors? So first directors. First directors are those directors whose name in the articles of association or chosen by the initial subscriber, which is provided under Section 152. Then, on the other hand, subsequent appointments, it is done by the shareholders at the annual general meeting or by the board for casual vacancies. Now, board of directors are appointed by the board. The board can appoint additional, alternate, nominee, and casual vacancy directors under special circumstances. Here, special circumstances means the death or illness of a director, so we can appoint additional, alternate, and nominee directors. Now, directors are also appointed by tribunals. So, the company law tribunals has the power to appoint directors under Section 242, subclause J. Now, directors are also appointed by small shareholder because to present their interest by the shareholders. Then it is provided under Section 151 that at least one director be elected by small shareholder. Here, small shareholder means holding a maximum of rupees 20,000 share values. Now, we will talk about some legal provisions for number of directors. In case of public companies, minimum number of directors is 3. In case of private company, minimum number of directors is 2. In case of one-person company, the minimum number of directors is 1. And in all the 3 companies, the maximum director is fixed 50. If a company wants to have more than 15 directors, then it can be increased by a special resolution by the board of directors. Now we will talk about qualification. There are some mandatory requirements for directors. women directors. In case of listing companies and certain other classes of companies, must have at least one woman director, which is provided under Section 149, subsection 1. Why we require a woman director in a company? Because women are the same capable as a man, and they represent an important position in a company, and they will contribute in the company, and it ensures transparency amongst the members of a company. Then second, a resident director. At least one director must have resided in India for at least 182 days in the previous year to become a director of a company. Then written consent. Directors must provide written consent in a journal meeting, and this consent must be filed with the registrar within 30 days of appointments, which is provided in Section 152. Now we will talk about some qualifications and disqualifications for directors. Eligibility. Only individual like natural person can be a director, which is provided in Section 149. Next qualification is like sound mind. Directors must be mentally capable of managing the company. So we will talk about disqualifications. Disqualifications provided in Section 164, like undischarged insolvent, convicted of an offense involving moral turpitude, or failing to file financial statement or annual return for 3 consecutive years. From these grounds, a director can be removed from the company. So next we will talk about some director identification number. It is a unique number which is allotted to the director by the central government. Because if a director wants to become, in a company, there is a DNI number which is allotted to the director to become a director for a company. So application. Every director must apply for a DNI from the central government, which is provided in the Section 153. Then allotment. The central government shall allot the DNI within 1 month of the application, which is provided in the Section 154. Under Section 155 provides that only one DNI is allotted to the director, not more than that. Then intimation. It is the duty of the director to intimate about their DNI to the board, to the company. Then it is the duty of the company to inform the registrar within 50 days of receiving the DNI, which is provided in Section 157. Then punishment. If a director fails to provide their information about DNA to the company, to the board, then he shall be liable for a punishment, which includes imprisonment up to 6 months or a fine rupees 50,000, which is provided in the Section 159. Now we will talk about the duties and liabilities of a directors. We all know directors are the important assets for a company. So director must act in a good faith with due diligence and in the best interest of a company, which is provided under Section 166. Then, on the other hand, director has a personal liability. Directors can be held personally liable for non-compliance with the provisions of the Companies Act. Then, resignations. We have seen directors can be disqualified from the following grounds under Section 164. Now, if a director wants to resign from a company, so the procedure comes under Section 168. A director can resign by giving written notice to the company and a board, which must be informed to the registrar. If a director shall commit any offense during his tenure in the company, after the resignation of a director, such director shall be liable for that offense. I hope we will cover all the aspects of a director appointments, their qualifications, duration, and duties and liabilities of a director. So we will end this video here. Thank you so much.